thanks for coming today, and I certainly appreciate your passion and wanting to protect vulnerable children. I'm just a little concerned with when you talk about page 2, line 4. You want to change actual knowledge to any knowledge. Could not any knowledge be that you heard something happened, and you're reasonably sure that you think it may very well have happened, but you're not 100% sure, and you want to be very careful about making accusations? I mean, do you want that to be in law, that if I heard something, if I heard that Senator Norman is smacking a kid around in his office, and I heard about it that happened 3 months ago, and I mean, that's why I think we don't want any in there, and it's not my bill, but I mean, we don't want any in there, because you could have a situation where somebody could say, well, you knew that rumor was going around and you didn't report it. I mean, can you elaborate on why you think any is a good word there?
Our understanding of how this has evolved is based upon a Montgomery County prism, the lens through which we see all of this.
Okay.
None of these cases are adjudicated or even brought to closure on a first report. There are many instances of people who notice things and report them.
You're talking about actual instances of children being abused in the school system in Montgomery County?
Yes.
Okay.
Where teachers, reporters, every teacher is supposed to be a reporter under the law. That is our
if they
witness.
If they witness, yeah.
But if you put all of the actual knowledge on the principal, they can never meet the standard of legitimate reporting.
Well, that's why actual is good, because if they know and they have actual knowledge, and I'm not an attorney, but it doesn't actual make it a little more concise than any, because that way you can be sure, I know this happened. It actually happened. I didn't see it, but I know it happened, versus I heard a rumor that it happened. Because, rumors can get started in all sorts of, and by the way, Senator Norman uses us as examples all the time. That's why I wanted to use him as an example. But so Wayne Norman loves everyone. He's not hitting anybody. I guess we don't want to get into a debate back and forth. You're coming on real strong, and I understand where you're coming from. I think any would be kind of too broad.
Any is broad, but we thought actual was too restrictive in terms of it's either, does actual mean eyewitness?
Okay. And then my last question was just, you said strike witnesses the act. Well, that's an or there. So, I mean, you'd want that in the law. It's not an and, it's an or. So it's has actual knowledge, or let's say any knowledge, whichever, of the abuse and neglect, or witnesses the act. Why would you want witnesses out? Witnesses should stay in. Or I guess you're saying it's superfluous if you have any knowledge. Is that what you're saying?
Yes.
Okay. Thank you. I was just curious. Thank you. Thank you, Mr. Chairman.
You're welcome.
Thank you very much.
You're welcome.
Joyce went Bailey Country. Danila Shaviko. Sorry.
Good afternoon, members of the committee, distinguished chair. I just had to quickly rewrite my testimony here after everything I heard. With all due respect, I have to set the record straight. This is not the tightest bill in the nation. When it comes to criminal penalties, it is just blatantly not. And there are differences between the Senator Shank's bill and the previous bills that have failed. And really, Maryland is only one of the 2 states where we don't have reasonable criminal penalties, and the current mandate is useless. And the good bills that have been brought to this House for the last 17 years have failed. Now, in Penn State, it's not just Jerry Sandusky that's in jail. It's the Penn State administrators that help cover this up, that are serving prison sentences. Washington Post in Montgomery County had to admit that we've had case after case after case where administrators knew and did not do anything. We discussed the Cloverly case. If this bill passes, all of those people, the superintendent, the principal, they would be off the hook because they didn't have actual knowledge, because they were not in the room holding the candle while these crimes have occurred. And this standard is completely counterproductive. And honestly, I'm trying to figure out a way how to say this respectfully, but this bill is a sandwich no person would eat, okay? And it's a travesty. And if any knowledge is too much of a burden for you, change it to constructive knowledge, okay? Because actual knowledge requires that the principal or superintendent are there in the room. And that is a threshold that is impossible to meet because they're not everywhere all at once, okay? The superintendent is not monitoring the girls' bathrooms in some elementary school. So this is an impossible to meet threshold. Thank you very much.
Senator Broach, you've got a question. First of all, thank you.
Thank you for your testimony. It's refreshing for this committee to hear frank testimony, so we appreciate it. So I tend to side with my colleague across the aisle, Senator Reedy, because I don't think if you say actual knowledge does not mean that you witnessed the act. It means that the superintendent could have come over and said in your office, guess what I just saw? So if the superintendent comes into my office and I'm a teacher, or the principal comes into my office and says, guess what I just saw? I've got actual knowledge because he saw it, and it can go down 1 degree there. So I don't read that the same way that you do.
Well, then we have a difference of opinion because we're basing our testimony.
Do you see the point that I just made?
Yes, I understand your point, and we've had a lot of conversations back and forth on actual versus constructive knowledge, and our reading of it is actual knowledge is an impossible to meet threshold, and we can respectfully disagree on that.
But the problem is that if you struck the word and put any knowledge, I think that this senator is correct. I mean, look, this is Annapolis, and rumors fly all over this place every day, depending on who it is and what's going on. We all have a lot of knowledge, any knowledge of a lot of different things, and I just think that that's so broad. I think it would really bring people into the loop who had heard rumors.
I hear you on that. But remove any, put in constructive, because right now, if a principal gets approached by parents or students or concerned teachers, and time after time after time is given reports, this bill leaves them off the hook.
What is? First of all, I forgot, what organization are you with?
I'm testifying as an individual.
Okay, but what does constructive knowledge mean?
Constructive knowledge means, actionable knowledge where somebody else saw it and then, made a report. And actual knowledge, as it is being defined by the experts that we have working on this, and we've been talking to everybody in the state about this. We've talked to people who've been following these criminal penalty bills and seen them fail year after year. And they're saying actual knowledge is a threshold that is impossible to meet and lets these people get away with it.
Okay, I appreciate your input. Thank you.
Thank you so much.
Senator Kelly.
Would you agree that in a limited situation that will occur now and then, it would have meaning? For an example, the Sandusky case, because there were the coaches that had seen and they did not. And that's why. But the point I think that you're making is that in 99% of the cases, that isn't going to be the case, and that for those, that 99% would fall outside the parameters of this bill.
Well, they wouldn't just fall outside of that, Senator. They would be protected by this bill.
Oh, well, in any case, they aren't included in this bill.
Right. Yeah, and this bill, as it is, undermines the existing mandated reporter requirements. So.
Anybody else? Let me just set the record straight on that last point. That's a false statement. So let me just explain to you why, just because this is for posterity. The mandatory reporting law is what it is right now. There is no criminal sanction, and this bill doesn't touch it. So nothing in the bill undermines any of the current law, just so you know. Okay, so please don't say things like that. I certainly wouldn't be coming in here undoing the law that we have now. This is supposed to enhance it, and it does not go that far. You are correct. When I said it was tight, we've been having conversations about the term willful blindness, which would be more along the line of constructive knowledge, which is what you're talking about. We're trying to get to a point where we can get some kind of an agreement. Right now, the mandatory reporter is required by a negligence standard, knew or should have known, and they're required to report. And the punishment is to their license. Nothing in this bill touches that. The question is, what are we going to put the person in jail for? Criminalizing what they either, if we just criminalize what they knew or should have known, you're criminalizing a negligent act. This is going about as far as you can in the other direction and saying, well, we're going to have a criminal sanction for the worst of the worst. There is obviously a range of folks, including what you're talking about, constructive knowledge, willful blindness, malicious. There's a lot of words we could put in there, and we'll discuss those. But just for the record, what you just said in answer to Senator Kelly is factually incorrect. Thank you.
Thank you so much, Chair.
Julie Worcester.
Thank you, Mr. Chairman, members of the committee. Julia Worcester on behalf of the Maryland Psychological Association, and I may or may not have been here in person last year to testify on this bill, but I have submitted testimony in years past. We do oppose this bill for a very narrow reason. We've worked with stakeholders over the years, but I wanted to address a couple of points that came up first. The question about the term any. When you are a licensed healthcare provider, particularly a licensed psychologist, you are most likely in a one-on-one session hearing discussions with your patient, and any knowledge is not enough to go make a report with Department of Social Services that could be investigatory with sufficient evidence. So any knowledge is not a standard that we think would be helpful to this statute. One of the other issues that we have come before you in previous years in opposition to this bill is most of the time when we have heard the testimony and the other examples that have been given, it is almost always in the educational system or a daycare center. And unfortunately, this bill always goes to the family law article, and our main concern would be, if you really want to address the system, let's look at the education article. When something wasn't reported up the chain of command, let's go in there and find a protocol, because what is different for teachers or law enforcement or healthcare providers, they're all governed very, very differently. And you all don't hear a lot of the health occupations bill that I hear day in and day out in HGO and EHE. But the licensed healthcare providers, your physicians, your psychologists, your social workers, your nurses, are all governed by very, very strict licensing boards that have the ability to penalize providers for thousands and thousands of dollars, many times up to $50,000, and strip their license and report to national data banks to make sure that they cannot practice across state lines. So that's a pretty big deterrent that we believe is, and we know is already in the code. So that's one of the reasons why we have an issue with this specific bill. In conclusion, we do have an alternative. If you took the section of new law that has been offered and put it into 5704A2 on page 2 of the bill midway through, if acting as a staff member of a hospital, public agency, child care institution, detention center, et cetera, for the higher ups, because we believe that really what we believe the intent of the committee and many of the stakeholders is to get to those when it is reported from a teacher to a principal and the principal doesn't continue, or a daycare worker to the daycare owner, and it doesn't go beyond that to the child care administration. That really might be where those sanctions might need to be, at the higher levels, when the reporting is happening, but it hasn't concluded or it hasn't gone beyond where you need to go. So that's our way of trying to help the situation, and we're more than happy to continue to work with the committee on this. Just so you know, those are the only reasons we oppose this bill, are for the details. Thank you so much, and I'm here for questions.